Okay, Attorney Steve Vondran, licensed practice law in California and Arizona. We're back. Part 2 of Cumis Counsel. Okay, so we were talking about Cumis Counsel, which arises when you have an insurance company that issues a reservation of rights letter when someone, let's say a real estate broker gets sued for fraud, breach of fiduciary duty, negligence, misrepresentation, all kinds of things that you can get sued for. Some things the carrier is going to cover, some things the carrier is not going to cover, and they'll issue a reservation of rights letter. So we talked about the San Diego Federal Credit Union versus Cumis case. That's the case that got the whole notion of Cumis Counsel started. And we talked about how a defendant in a case, also known as the policy holder, because they hold an insurance policy and there's an omissions policy, how that policy holder might want to invoke the right to Cumis Counsel and make a case to the insurance company that you have a right to insurance independent Cumis Counsel. Okay, so now again, we talked about the Cumis case and how that was basically limited because there were so many attorneys running around going, well, Cumis. Every time that there was a reservation of rights letter issued by an insurance carrier, somebody's saying Cumis. And then wanting the carrier not only to pay, of course they're paying the defense firm, the defense law firm money, they're paying them hourly fees to represent the case. Now you have Cumis Counsel coming in and saying that I need to be paid too, so the carrier's paying two different sets of payments here. So naturally there was a backlash to that. Insurers through their lobbies got together, like all big organizations do, and they eventually helped lobby for the passage of a law that would help sort of limit that so that every case didn't have Cumis Counsel. By the way, more information, go to cumiscounsel.info. We've got a sample demand letter up there. If you're involved in a case and you or your counsel is looking for that letter where you say, I want to see what it looks like, demanding that and setting forth some of your rights, it's up there, and you can find that at cumiscounsel.info. That'll take you to our website. But back here, going back, so we're talking now about the limitations, and basically your limitations, let me grab this here, were provided by California Civil Code, hot off the press here, California Civil Code section 2860, which basically talks about when an insurer reserves its rights on a given issue, and the outcome of that coverage issue can be controlled by counsel first retained by the insurer for the defense of the claim. A conflict of interest may exist. So again, we talked about this. You reserve your rights, a conflict may exist. So this statute's talking about that. It talks about that it's no guaranteed conflict, basically, if there's a claim for punitive damages or there's a claim in excess of your insurance policy. Say you have a $100,000 policy and they're seeking $1 million. That doesn't in and of itself create a conflict. Because what happened with this statute is, and some of the case law that is evolved, is the courts may be requiring you to show an actual conflict, not a potential conflict. Remember, in the Cumis case, a potential conflict was enough. However, the statute and the case law that has resulted is pointing us down the road toward showing an actual conflict of interest, although there are some arguments that need to be made. Even if there's a potential conflict of interest, there are some arguments that should be made. Okay, so, but this talks about just being sued for punitive damages, which happens in a lot of cases. Plaintiff attorneys are suing each other, their clients, for punitive damages, attorney fees, all these kinds of things, suing in excess of the policy limits. That in and of itself does not create a conflict of interest per the code. The code also talks about when there is a conflict of interest, the kinds of things that the insurance company can require if they are going to go ahead and appoint Cumis Counsel. Okay, so if the insurance company says, yes, fine, we have reserved our rights, we do see that there is a conflict of interest, and we are willing to pay for Cumis Counsel, there are some requirements that can be, don't have to be, but can be imposed. The insurer may require the selected counsel to have 5 years of civil litigation experience, and have errors and omissions coverage of their own. So that is one of the things. And the other limiter is Whereas you used to have a lot of firms coming in and saying, okay, I'm Cumis Counsel, it's $500 an hour. That's my fees, $500 an hour. So the insurance companies over here are making $1.25 an hour, $1.50 an hour. These attorneys are coming in wanting $400 or $500 an hour. And they said, wait a second. The statute covers that. Section 2860 talks about, subsection C talks about paying the ordinary bills for the ordinary services that you would normally pay somebody in that community. So don't think you're going to get $500 an hour if you're applying to be Cumis Counsel watching this video and thinking you're going to get your meal ticket. As courts have said, it's no meal ticket. So you have to look here for that, okay? So let's talk about a few other things. That's here. What else do we have in our code section? Waiver, a potential client such as a defendant, broker, real estate broker. We represent a lot of real estate broker clients. They can waive, you can waive your Cumis Counsel rights in writing. So if somebody's asking you to waive it, read it carefully, consult us, please give us a call before you just go and sign that, because you could be risking quite a few different things and increasing your exposure instead of limiting it. So, so we have that. Again, we talked about, let's see, let's go back over here. So we talked about a few things. So according to your carriers, they're going to want a significant and actual conflict. So you're going to have to be prepared to make that case. As I mentioned, there's a footnote in the Cumis case, footnote 7, which talks about potential conflicts of interest. And you know, when you get into a world where you say it has to be an actual conflict, some conflicts don't raise their heads until you get to trial. And then you say, oh my God, there's a potential conflict. By then it's too late, right? So issues that could be raised to rebut this need for an actual conflict. Footnote 7 to the Cumis Counsel case. Take a look at that. Some good language in there. We have a sample in our sample letter, cumiscounsel.info. Check that out. But you can see some examples, and I have a sheet here we'll go over. I had a sheet, I should say. Where? It was right here. I have a sheet, and we'll go over this in a second. Some examples of when an actual conflict may be found to exist. And this is from the James 3 Corporation case, 91 Cal. 4th, 1101. Okay, so there are some issues, for example, where the insurer represents both the plaintiff and the defendant. Obviously, that's a conflict. That's one. We discussed written waivers. If the right of reservation is withdrawn, and your letter may want to consider asking them to withdraw the reservation, then of course no conflict exists. Okay. What do we got? So we've talked about a lot of these things. Not every reservation of rights letter creates a conflict of interest. You're going to have a potential cost gap here between what this counsel wants to charge and what the common rates in the industry are. So we talked about that. And the services by your Cumis Counsel are basically to monitor and to provide services reasonably required to defend the insured. So it's not everything is reasonably required to defend the insured. You're just making sure their interests are protected. You're going to have your special privileges. As Cumis Counsel, you're going to have your attorney-client privileges. Again, hypothetical conflicts, not usually enough to get you there. Problems, again, if you're not being treated properly, bear in mind that you always have potential against your law firm here for malpractice, or your insurance carrier here for basically putting, as we put here, using the defense panel to the detriment of the insured. So if they're doing something to put the insured, your defendant, at detriment, that's also a potential problem. Okay, so that's basically Cumis Counsel. It's one of those things where if you're involved in a lawsuit, particularly in our instance, real estate lawsuits, we can help you explore your rights and to discuss what your rights may be, what your exposure may be. We can discuss whether Cumis Counsel demand is proper in your case, and if so, we can represent your interest in a Cumis Counsel independent counsel relationship. So this is Attorney Steve Vondran. We thank you for watching this two-part series. And again, more info, cumiscounsel.info.